All right. The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having been before this court are admonished to draw nigh to the court, now sitting.
Thank you, everyone. Please be seated. Good morning and welcome to the Kansas Supreme Court. I'm Chief Justice Eric Rosen, and I know all four of you sitting here are very familiar with our process, but I'll explain it to those that are watching virtually, is that all the judges and justices are familiar with the facts of the case and the parties' arguments. We have reviewed the briefs and are familiar with the authorities relied upon them in support of their briefs and arguments, and otherwise prepared for this morning's argument. We look forward to the parties' oral arguments and our exchange with the attorneys. And just as a note for those that, again, are here this morning and watching virtually, obviously Justice Standridge is not present this morning, but she is viewing the arguments virtually and otherwise participating in all of the case decisions on the cases today. With that, Mr. Doug Shima, please call this morning's docket.
The first case on the 9 a.m. docket for Tuesday, May 19th, 2026 is appeal number 128652, State of Kansas versus Billy Shane Barker, appeal from Cherokee County.
May it please the court, Corey Call, appellate defender representing Billy Barker. Your Honor, I would like to request 3 minutes for rebuttal.
3 minutes. Thank you, Mr. Call.
Thank you. President, ready for argument.
May it please the court, the state appears by Chris Ailslager, Deputy Solicitor General, present and ready for argument.
Second case, appeal number 128936, State of Kansas versus Jeremy T. Miles, appeal from Sedgwick County.
May it please the court, Sam Shire of the Capital Appeals and Conflicts Office appearing on behalf of the appellant, Jeremy Miles, present and ready for argument. Your Honor, may I please reserve 3 minutes of rebuttal argument?
Yes. Thank you, Mr. Shire.
May it please the court, Assistant District Attorney Matt Maloney for the state, present and ready for argument.
Your Honor, that concludes our 9 a.m. docket.
Thank you. I will now call the case of State of Kansas versus Barker. This is case number 128652. Counsel, you may approach, and Mr. Call, when you're ready, you can proceed.
May it please the court, counsel. Yeah, just been doing this. I've got 3 minutes for rebuttal. Just to
Yeah, I did note that, but
Thank you very
it's
much.
always good to double check.
It was a double call. Mr. Barker was convicted of 1 count of first-degree premeditated murder, 1 count of criminal possession of a firearm, and 1 count of possession of brass knuckles. We raised 2 issues in the brief, both dealing with the murder. The first issue was a failure to give lesser included instructions, and the second issue dealt with procedural error. We've all been around the block on here. We know that generally the way things work is I'll talk about issue 1 and the questions, we'll talk about that, and then we stop and we talk about issue 2. Here, I think it might be kind of interesting, especially towards the end when we get into the harmless error analysis, to kind of talk about them and see how they work together. Because I think the key to this case is the importance of Cousin Larry's testimony on the jury's finding of premeditation. And I think that plays on both issues, and it's interesting how those work together. But we'll start with the first issue, which was failure to give lesser includeds. I'm hoping we can move pretty quickly to the harmless error analysis. He was charged with first-degree premeditated murder, and we're challenging the failure to give second-degree intentional and a couple of reckless lessers. Obviously, the analysis is, are they legally appropriate? Are they factually appropriate? They're lesser included offenses. I don't think there's any doubt that they're legally appropriate. Factually appropriate, especially the second-degree intentional is, I don't know if this court has called it a nesting lesser, but I think of the Russian nesting dolls. It seems like it's just the only elements missing from first degree to second degree intentional is premeditated. So under Haberline, in those cases, it's factually appropriate. And so the judge should have given it. So we get to harmless error. And the state, the question is there sufficient evidence that it wasn't requested? So I'm in clearly erroneous land. So I have to convince this jury that this court that the jury would have given a different verdict. So we look at the strength of the premeditation evidence. What did the state have? And the state argues that it relies on 3 statements made by Mr. Barker prior to the incident that occurred on his property. And the first 2, I do not believe indicate a premeditation or intent to kill or relate to his intent to kill Levi Porter. The first one was he ran into Josh Walker, friend of the victim, Levi, at a store. And there'd been some dispute between Levi and Billy Barker about some parts that Levi would with Billy's permission, take off his truck and sell on Facebook Marketplace, and the finances were a bit of an issue. So Josh Walker made a joke about a bike. He's like, "Oh, I'll take some parts off this bike." And Billy said, "I'm going to teach you boys a lesson," which that doesn't feel an intent to killy to me. That's just sort of a threat, maybe a violent threat, but not an intent to kill. The second one is Billy was talking to Levi's grandmother, who he was friends with and he knew. And Levi had taken some ramps and Billy wanted them back. And he said to the grandmother, "Well, maybe you better talk to him, because if I talk to him, I might do something I regret." And again, there's sort of implied violence there, but there's not a kill. Now there was, as she said, as she testified, apparently she made some sort of motion with her hand. And the district court said, when he said that, you made a gesture, is that a stabbing motion? And grandma said, "I guess you could say that." And then after they had this conversation, they continued on with what she described was a very pleasant conversation. And it seems there's no grandparent in the world that would have a pleasant conversation with the fella that just told her that he was intended to kill her grandson. Which brings us to Cousin Larry. And 2 months before the incident on the property, Cousin Larry said he went out to the garage with Billy. And pretty much as soon as they got there, Billy said, "Do you know Levi Porter?" And Cousin Larry said, "No, I don't know him." And Billy said, "Well, I am going to blow his brains out." And Cousin Larry was shocked. And he said, "Well, what did he do?" And Larry said, "Well, I don't want to get into that, but I'm going to shoot him in the head." And Cousin Larry said, "Well, you're a big guy, but can't you just whip his ass?" And Billy said, "No, I'm going to blow his brains out." Now that is 100% evidence of that he thought about the killing, premeditation. So the question is, did the jury rely on that? I think that's the piece of evidence that the state has to hang their hat on. And there are problems with that. One, if you read Cousin Larry's testimony, there's some, Cousin Larry wanted Billy out of the house. Billy was living with Larry's mom. He wanted him out of the house. It took him a year to report it to the police. Immediately after the shooting on the property, Billy called the police. So there's a lot of reasons why a jury would not rely on that testimony as evidence of premeditation. And if that doesn't support premeditation, then it was error, it was prejudicial error not to instruct on the second-degree murder. So if that evidence, the jury did not rely on that, then I believe the failure to give second-degree lesser was harmless. But what if it was important?
Can I just stop you there and
Yes.
ask a question that's growing in my mind, which is, and you may not be able to answer.
Uh-oh.
Do you have any sense of why the second degree instruction was not requested?
No, I don't.
Because this is basically an all or nothing jury instruction, is it not?
Yeah, and that is sometimes a strategy. I don't know if they thought it was. I mean,
I'm just thinking in my head, what was this jury supposed to do?
Yeah,
I mean, they have strong evidence of the homicide, and they have one option.
that's exactly right. And the other thing is that Billy testified, And he gave history. He said it was self-defense. And so,
Was this, is there any suggestion this was trial strategy to put in front of the jury kind of the maximal charge set off against a self-defense?
well, I would guess the evidence would be that the judge explicitly asked, are you requesting defense? Are you requesting lessers? And the attorney said no. So it wasn't an oversight.
So what are we, maybe that's really not in front of us, but I'm curious we've confronted this kind of situation before. What are we really supposed to do with that?
Well, I think what you've done in the past, which is you look at, if you don't request it, then I face a high bar. And I have to show you that it'd be fairly because the jury would have done it. But as far as like an invited error or it's a choice by the counsel, I mean, the flip side of that coin is that a defendant can choose to go all or nothing, and they can't. The judge can say, no, this is the evidence. And that's what we've said, is that what we want to do, and I think this may be fair, is that we have these laws. And if the state charges it, it's a fair charge. It's covered by the indictment. And if the jury, whatever crime the jury believes the defendant is guilty of, then that's what he's guilty of. And it's the judge's job to put those options in front of the jury so that they can choose which crime the legislature has set out. And the defense counsel can't say, oh, we don't want that. Well, if that's the crime that you committed, then that's the crime you're guilty of. And if a jury finds you guilty of that,
Follow up.
we let it go.
Just go one step deeper. Who erred here? The trial court judge said, my reading, this is the weekend, the Friday before jury instruction or the day before, I've researched lesser included before trial. There's some case law on that. My reading is that it's not required to be given. Is that right?
I don't believe that.
The lesser included instruction statute says shall be instructed on all lesser included.
Yeah.
So who erred here? Did the court err here in terms of giving that kind of, that there's some permissive statutory leeway in not to give lessers?
Yeah, I guess I would say that the error was the failure to give the instructions. It was nervous when
the court says I'm not required to, and that seems contrary to statutory direction.
And this court's law, I would agree with that. I'm always nervous when you read a judge say, I've researched it and this is what I found. And I say, gosh, I don't think that's right.
Well, it just stood out to me that I don't think that's,
I think that's wrong, but I think that error could have been cured by the giving of instruction. In the end, the error, that was maybe the cause of the error, but the error was the failure to give the instruction.
State claims that that's an invited error. And, if you look at it in terms of the court saying wrongly, let's just say the court's incorrect. I've looked at it. I don't think we have to give these instructions. And the defense counsel says, I've looked at it. I don't think so either. And then you try to apply, in the invited error analysis, a but-for test. Seems to me it gets pretty close. That's their argument.
It is their argument. It is their argument. And I think that it would have to, I think that would change some of the law, because I think on invited error, what this court has previously said is that the defendant has to take some sort, can't just acquiesce to the judge's, and I certainly agree with you that it's different at the instructions conference at trial. Are you requesting these instructions? No, we're not requesting. Okay, well, I don't think that gets anywhere close to invited error. Right? He's just saying, no, I'm not requesting it. That's the clear earlier statute. Maybe if the judge misstates the law and the defense counsel acquiesces to that or doesn't disagree with that, that's unfortunate. But
affirmatively agrees with it.
Yeah, right.
In this back and forth
it
case. But I think from the state's perspective, they're going, now, wait a minute. Now we got to come up to the Supreme Court, and we got Mr. Call here saying this is a whole bunch of mistakes here and requires a reversal, when the defense counsel agreed with the court, in this exchange. So I'm trying to figure out how close to the invited error line. I know our but-for test.
Yes,
I'm trying to
yes,
figure out
yes,
how
yes, yes.
close to the line this one is.
Yeah, I, boy, it's, when the defense counsel agrees with the district court, then certainly they're not putting forth an option for the correct option for the court to follow. Nonetheless, I think this court looks at who was driving the decision here. Who was that, not just that, did counsel have an opportunity to change the judge's mind, which even if you agree with it, whether you say, I don't have the objection to that, or you stay silent, it's failure to correct the district court judge's mistakes. I think that's the invited error. Because invited error that's a big hammer of just, we don't even consider whether this was wrong on a first degree murder.
I don't mean to harp on this.
No.
But failure to correct the court when the court asks, I think is the other. I mean, this is not just a court doing something and the defense being quiet about it. This is much more of a nudge, it seems to me, if not a push.
Well,
to error.
Well, I would push back on the push, because I think, and not to get too etymological here, but we're talking about invited error. Did the defense counsel invite the error? In my mind, did the error originate with the defense counsel? Because you can't cause the error. You can't be the genesis of the error in the district court and then come back up on appeal and say the error. But that's not the case here. The genesis of the error was the district court judge. And I mean, if you flip those, and where defense counsel says, well, I don't think you have to give the lessers, or we don't want the lessers, and the judge says, well, I think that's right. Well, that's a different dynamic, because it would be defense counsel who was the genesis of the error, who invited the error. Here it was the district court who began the error. And certainly it's different, like I said, between not objecting and invite. But I think you have to look at, where did the error originate, and did defense counsel, was it the genesis of the error?
Can you remind me from the record why the district court was doing this research and came to the conclusion that it, quote, did not have to give the instruction?
It wasn't clear from the record. I will say it's
just
not
a strange. It strikes me as very strange. Why would a district court do that?
I think that it's a murder. So, I mean, this doesn't seem to be unusual, lessers, but
the reason I'm pursuing this is twofold. One, a district court might do that research if the lesser was requested. In other words, you get a request and you're like, okay, well, I need to find out whether I have to give this. The other reason you might do the research is if the defense affirmatively does not want the instruction given, and the district court says to itself, well, I better check the law and see whether I still have to give it over the defendant's objection. What I'm really trying to figure out is what happened here. In other words, this is such a strange, it strikes me as a strange sequence of events. What it looks like, but what I'm not sure of, is that the defendant did not want this instruction. And the court may have been looking to see whether or not it had the leeway not to give it when the defendant didn't want it. Does that make sense?
It does make sense. I don't
Give
think
me your best.
Sure. Yeah. I don't think the record that we have reflects that. Now, obviously, there are conversations which occur off the record in chambers or in passing or whatnot, where something that may be said. But I think we need something firmer on the record for this court to rely on. It is an unusual situation.
Doesn't the record? Oh,
Go ahead.
I was going to say, doesn't the record say that the district court judge did that research before trial? And can we infer anything from that?
I don't know. I know
I mean, I'm looking at the record. It says, I've researched lesser includeds before the trial, and then flushes out some of the case law. Well, not in particular. He just says there's some case law.
Right.
With flexibility.
I don't know. I guess the reason to do it beforehand would be the instructions packet, in which case the defense did not request a lesser. So maybe it goes back to, well, why didn't they request a second degree? I need to look to see whether I need to give that sort of thing, that, if it's not requested, Well, the prosecution didn't request it. Defense will, do I have to give it? So you look at it that before trial, maybe that's the answer. So,
I want to move you over to your prosecutorial error.
oh, thank you. I was,
On the contention that the prosecutor misled the jury.
yes.
Is that, I think I need you to state it for me because it seems to, I'm not sure I understand it. It seems to be founded on your reading of McClin. And I'm just trying, and I'm not sure I read McClin the same way you are. But
Okay, yeah.
I need you to just cover that ground for me.
Sure. Well, and part of the problem is that, so the issue is that the state, and to my embarrassment, I'm reading this from the state's brief because they put the full quote in there, and I put the excerpt I was concerned in, but the state on page 18 of the state's brief, to give you the full context of it, they're talking about premeditation, and that's to think the matter over beforehand. And so the state premeditation means he thought about it. And I'm not saying he thought about it the moment he shot him, just he thought about it well before that. And he goes through the grandma's house, he talks about Josh Walker, and then he says, this is what I'm complaining about. He thought about it explicitly with Larry Link during the cigarette smoke in the garage of the house that they were both visiting. He said explicitly, I'm going to shoot Levi Porter in the head, and he said it more than once. So it's the combination of saying premeditation means you need to think about it beforehand. And then telling the jury he explicitly thought about killing him beforehand 2 months earlier in the garage with cousin Larry. And so the problem that I have is that premeditation is not some thought you have, and then you're walking around with a scarlet P on your chest for the rest of your life, carrying the premeditation with you. And that element has been satisfied for the jury. Premeditation, this is where McClin comes in, I think. Premeditation is you have to have thought about it. You have to have thought about the act that you're going to commit. And it's a temporal, it's a temporal thing. And it doesn't have to be necessarily, stand next to it, but it has to be, you have to think about the act that is being charged, the intentional act of the murder that they say you committed. That's what you have to think about. And that you had a thought 2 months earlier, and then according to their roommate, they lived together, there was no bad blood between them. There's sort of this interim period here of 2 months where then that premeditation is somehow satisfied. Now, as I said, I do think that had the state tied it together, I mean, the fact that he thought about it 2 months earlier could color the jury's opinion of what happened in the events. So, once you think about killing somebody 2 months earlier, it could be that, well, that shows that in the moments before he actually killed him, that he was thinking about it. That's evidence of that. But that's not how the prosecutor stated this. The prosecutor said, he explicitly said, I'm going to shoot Levi Porter in the head, and he said it more than once. As I read that, coupled with the premeditation means he thought about it, the prosecutor is saying that box is checked for the jury because 2 months before he thought about it. He thought about it before. That's what the definition is. That's what it's saying. And so,
isn't that an evidentiary challenge? I mean, doesn't that originate with the evidence? I mean, shouldn't that have been, if that legal theory is correct, shouldn't counsel have objected to the introduction of that testimony? Or objected to that testimony?
Defense counsel, you mean?
Correct.
No, I don't think so. I mean, because as I said, I think the fact.
Once it's in evidence, why can't he make that argument?
Well, he can make the argument that this prior thought impacted the killing, that Billy's state of mind and his premeditation immediately before or during the intentional act. But what he can't argue is that independently, 2 months earlier, that satisfies the premeditation because he thought about it beforehand. Sometime beforehand, anytime beforehand, he thought about it. Therefore, premeditation is met. So when it came in, it is relevant because if in a murder case, a guy saying 2 months earlier, I'm going to kill that guy. Well, that's relevant, but it's relevant to his state of mind in his premeditation of the act of killing, not just independently because he had that thought months earlier. So I would say it wasn't objectionable at the time it came in, because it was relevant, but not how the prosecutor explained it to the jury. And so, sum up, if I may, I know I've been going a while, may I ask, if Cousin Larry's testimony was not important to the jury, if it wasn't really reached the level of premeditation, then the failure to give the second degree murder was not harmless. If it was important to the jury, if the jury relied on that testimony to find premeditation, then it was the procedural error is not harmless, and the conviction needs to be reversed. Either way, the conviction needs to be reversed based on how important Cousin Larry's testimony is. Thank you very much.
Thank you.
Excuse me. May it please the court, Chris Elslegger, Deputy Solicitor General, appearing on behalf of the state. And I would say I disagree with my opposing counsel that we just jumped straight into harmless error analysis on this. And in fact, I actually, Justice Rosen would push back on the assertion that the judge necessarily misstated the law when she said she did some research and thought the instruction wasn't necessary, because perhaps the district judge read this court's decision in State v. Scaife, which was cited in our
They
brief.
did, and wasn't there a dissent in State v. Scaife? I know that because I authored it. And I took the exact position you're taking today, and ever since, that was a 2008 case, 10 times at least repeated that same argument. And that has never been the law of the state of Kansas. Once there is, the whole sufficiency standards on giving lessers, all that evolved kind of from that time.
Yeah,
And that's never been the law.
but critical in State v. Scaife, it said that a prosecution, in a prosecution for premeditated murder, a lesser included offense instruction will be required when there is no direct evidence as to the circumstances of the killing, and the evidence introduced against the defendant is wholly circumstantial, which implies that if there is direct evidence, then a second degree murder instruction is not required.
Hasn't the line of cases really developed since then in very explicit ways?
I would
say
disagree.
that you always have to give.
Well, no, because the little carve out in Scaife is still there. Because the court said, although admittedly infrequent, direct evidence of premeditation does exist in some cases. For example, an associate might testify that the defendant shared his or her plans to kill the victim, which is exactly what we have here. I mean, he said it. He said to Larry, I'm going to blow his head off.
It might have merit if the case law stopped at Scaife, but it doesn't.
Well,
It goes on in case after case after case to say, and again, I was with Justice Rosen in dissent from these decisions, but the case law says it's a sufficiency test. And when all you're doing is adding an extra element, it is sufficient. The evidence is sufficient as a matter of law to support a second degree murder charge.
Well, I thought the same thing until I dug into this case, and I read Scaife, and Scaife doesn't appear to have been overturned. I mean, that carve out is still there. It just doesn't come up very often.
So
in fact, this is the rare case where the Scaife carve out actually exists. I've never seen another case like it. I mean,
you're maybe inadvertently answering the question that I had here, which was trying to figure out what actually happened. I was trying to see my way to wondering whether this district court maybe didn't make what strikes me as a pretty egregious misreading of the case law by, for example, trying to decide what to do when a defendant doesn't want the instruction. But you're suggesting that really this district court judge may have just truly been sort of doing a de novo review of the law, came to this conclusion.
well, when I did, I like I said, I started out with the position like second degree murder instruction is always required because that's what I thought. But then as I dug through this and I read Scaife's there, hasn't been overturned. I couldn't find another case where this exact fact pattern happened. The carve out that Scaife made was when you have direct evidence, well, it's not required. Now, regardless, if we move on, I mean, you could say that carve out just leads to a harmless error. Perhaps that's what the SCAFE carve out actually means, that it's harmless when you have direct evidence of the murder. And you, again, here you've got the multiple statements that he made prior indicating that he was going to harm. Now, obviously, if you take the first statement to the kind of vague threat to Mr. Walker, you take the statement with the stabbing action that he made towards the grandmother, that's a little more plain. But when you add those together with the statement to Larry Langton, I'm going to blow the victim's brains out, I think you have pretty direct evidence of premeditation there. If just from the clear error standpoint, I don't think you can get to clear error. If you were to treat the SCAFE carve out as simply the path to harmless error, well, then you've got harmless error, if it was error in the first place. The other aspect of this is the invited error, which I think you start with the proposed instructions that were submitted by the defendant. Before any of this happened, he submitted written proposed instructions that did not include any lesser included offense instructions. So I think right there you get the
Case law doesn't care about that.
I think that when you were talking about where the push comes, where the genesis comes from, where the push comes from, that the discussion was, well, it came from the district judge asking. Well, no, actually, I think the genesis started with the defense when they did not request any, which is maybe that's what led the district judge to look into this. I don't, you know,
But we boiled it.
record
down.
isn't clear.
We've got the Douglas case, which I hope we don't overrule because I wrote that one. But it just says there are two circumstances for invited error. First one is affirmative request to omit. We don't have that, an affirmative request to omit. We don't have a request to add, but we don't have a request to omit. And then the second one is an affirmative rejection of the court's offer to give. We clearly don't have that. So aren't you stuck?
No, because yeah, you do not have either blatant option there. But I think when they submit written instructions and they don't request it there, then, and remember in the first jury, there were two different conversations about jury instructions. And in the first one, the judge asked about it and they said, no, we agree. We don't think it's necessary. And then they said, well, we're going to look, think about it overnight, do some research. We'll talk about it again tomorrow. And the second time, again, the defense counsel said, we're not requesting any lesser included instructions. I think you add that together. I think you get it's clear that you get an affirmative request for no jury instructions or no lesser included offense instructions.
Well, does the statute and our case law give the district court judge the discretion to do that? I mean, are we living in a world anymore where defense counsel can make that strategic decision, or has the statute and our interpretation of it made this really a compulsory process?
I want to remember that we're framing this as a case of invited error.
Right.
So if we're in invited error land, then I am admitting that it is error, that the statute requires the judge to give the lesser included instructions. Now, I've already argued that under SCAFE says it's not required because of the carve out. You can say that you could decide, well, maybe that's just a path to harmless error. But if we're in error land, then in addition to that argument, I would say it was invited. So
well, I'm just wondering how you could, I mean, if it's compulsory, I guess you could coax a district court judge into making error, but I'm just wondering whether there's even the option anymore to not request lessers as a defense strategy.
Well,
the way the statute's been interpreted in our case law, and whether that should be the case or not.
Well, there's a whole argument that shouldn't be the case.
Correct,
but,
and that's not really
that's not before the court, although I'd love to make that argument. But as it is, what I'm arguing is that the defense shouldn't be able to do that. Them doing it is error, and it's inviting error. I mean, they invited the district court to not give the jury instruction.
No, the district court did the inviting, I think.
I'm sorry, what?
I think the district court did the inviting.
Well, the district court just asked the district court didn't say, if you look at the cases where the court has rejected invited error argument, the district court in those cases made an affirmative statement saying, I'm not going to give this in spite of what your request. I'm not. But here, the judge relied on the request from the defense. The judge asked twice. And remember, even before any of this happened, the defense had submitted written instructions, requested instructions that did not include lessers. So the defense clearly from the very beginning did not want lessers. They did not request lessers. When the judge asked, are you requesting lessers? No. To me, that's pretty close to an affirmative statement that we don't want lesser included offenses. I mean, to me, there's no way around it. The defense clearly did not want any lesser included offenses. They wanted the all or nothing approach that Justice Stiegel discussed earlier. They wanted the jury faced with premeditated first degree murder or self-defense, hoping because they were afraid that they might find something in between. That was a strategic decision by the defense.
And there's no evidence of that strategic decision articulated anywhere.
Well, of course, you have to infer it from which, we all do. But from the evidence, I mean, if the defense, when the defense attorney did not submit a written request, did not include lessers in his written instructions, and when asked twice by the judge on two different occasions, they said, no, we're not requesting any lessers. I think that that's a pretty solid evidence that they did not want lesser included defense instructions. So I think if you have error, it was invited.
With the time we have remaining, can I run you over to my question to Mr. Call about McClenn? And it seems I don't read that if I understand the defense argument on McClenn, it's that you have to have this intention in an unbroken temporal thing. And so I guess I just want you to talk about how you view the McClenn case and this notion of the again, the contemporaneous temporal string of this intent to kill, that notion. Does that make sense?
Yeah, I mean, the basis for premeditation is simply to have thought the matter over beforehand. And usually we're arguing about, how, whether it happened and, whether the prosecutor said it could happen in an instant, or we're talking about the seconds or moments before the murder. This is a bit odd because they're arguing that, well, the fact that he thought about it a couple months beforehand, that's not evidence of premeditation, which seems really odd to me because I think that's clear evidence of premeditation. He did, I mean, I think there's probably a mountain of cases out there where someone has formed the idea to kill someone and over days, weeks, months, waited for the right moment to do it. That temporal distance doesn't change. That doesn't eliminate the premeditation. They've made the plan, and they eventually act on the plan. So I really don't follow my opposing counsel's argument, quite honestly. I don't know how that's prosecutorial error to argue that, hey, we have evidence that he thought about this beforehand. 2 months earlier, he said he was going to shoot this guy in the head, and then he does it. That's evidence of premeditation. I think that's a very fair argument by the prosecutor to make. That's not misstating the law. That's accurately stating the law. The law says premeditation means to have thought the matter over beforehand, before the act. And clearly the evidence indicated that he did. And I think as I was listening to opposing counsel here, it seems like he's asking the court to weigh the credibility of cousin Larry, and we're not here to do that. Clearly the jury believed Larry's testimony that Mr. Barker said he was going to shoot the victim in the head. And this court's not, appellate courts don't reweigh evidence or assess witness credibility. So I think that's off the table. The fact is that was the testimony, that was the evidence, and the prosecutor merely commented on the evidence. He made a logical inference that's consistent with the law that him stating he was going to shoot him in the head, and then he did it is a strong, a strong inference that he thought the matter over beforehand and carried out the act. I mean, I just don't know how that could be prosecutorial error. I don't know what the prosecutor. I'm befuddled by that argument, quite honestly.
Any other questions, colleagues?
Okay, I guess I've talked myself into a corner. All right.
No, do you have any further? You got a minute left, Mr. Elslinger, to get yourself out of the corner.
I have nothing left to add other than I would ask that you affirm the district court.
Thank you. Mr. Cole.
Your Honor, I don't know, when you're an advocate, you always think of the great thing to say as you're walking down the stairs. And so fortunately, you helped me because when you asked the question, you described my argument as an unbroken temporal line to the thing. And I want to clarify that that's not what my argument is. For example, if say he had made those comments to cousin Larry that afternoon, and then got in his car, drove around, and then later that afternoon. So it's more temporally, let me say it like this. The key moment for the jury to consider of whether he premeditated is whether he premeditated the act leading the act, whether he premeditated the act of the killing, the intentional act. Did he premeditate that? Is there evidence that he premeditated that act? And statements before, even if they're not temporarily, even a statement maybe a day before, could lead the jury to believe that his immediately prior to the act, that there was premeditation immediately prior to the act. As a part of the act, there was premeditation, that those existed. What the state argued here was that because the defense, because Billy 2 months earlier thought about it beforehand, premeditation, check that box. And as I read it, it wouldn't matter then. Did he premeditate on when during the killing, during the intentional act, when he was on the property, did he premeditate that act then? It doesn't matter to the jury because he thought about it beforehand 2 months earlier. And so it doesn't have to be an unbroken line. It just has to, the premeditation has to be the premeditation of the act. And those have to exist. And I use temporarily because I think that's how this court talks about premeditation. They have to exist together. And this seems completely separate from the act. It was 2 months earlier. And so I hope that clarifies that that's what I meant by that argument, is that standing alone, as I think the process.
Really just, I'm sorry to interrupt.
No, please.
Just saying that the statement to cousin Larry is too remote in time. Tag the defendant for premeditation.
Independently, the sole source of premeditation, yes, it can color his acts during the events on the property, but as the sole source of premeditation, yes, it is too remote.
Anything else? Any questions, colleagues? Thank you very much.
Thank you.
Thank you for your arguments this morning, counsel. This court will take your case under advisement. And what I mean by that is we will conference the case and decide which justice will be assigned to write a decision, which will be reviewed by all of the court. And we will then issue a decision, and that will be posted here within a certain amount of time and published on the kscourts.gov, and a news release will be issued. Thank you very much. I will now call the case of State v. Miles. Mr. Shire, when you're ready, you may.
May it please the court? Mr. Shire, again appearing on behalf of the defendant appellant, Jeremy Miles. It's my intention today to cover issues 1 and 2 of the briefs. I don't anticipate getting past those issues. If this court has any questions about the case that I am not addressing in argument, please do not hesitate to redirect my presentation. So moving to issue 1, we have conceded instructional error here. At trial, Jeremy stood charged of first-degree premeditated murder. During a jury instruction conference, the district court determined that it was both legally and factually appropriate to instruct on the lesser charge of intentional second-degree murder. However, when the time came to actually instruct the jury, the district court inadvertently, it seems, neglected to provide an elements instruction on the lesser of intentional second-degree murder. Without that elements instruction, Jeremy's jury had no principled way of ascertaining whether he was guilty of the greater or lesser charge in this case. As I read the state's brief, they are putting all of their eggs in the basket of contending that the error in this case was not clearly erroneous. But in my view, that is not this court's reversibility standard. First and foremost, we have a requested instruction in this case. And that, I believe, puts us in the territory of reviewing for harmless error. Furthermore, I think even if this court views the instructional error in this case as unpreserved, we still have a violation of my client's Section 5 right to a jury trial. I don't believe that the state contests that point in its briefing. And in State versus Gleason, this court held pretty clearly that Section 5 violations are not subject to clear error review anymore. When a jury instruction results in a violation of a criminal defendant's state constitutional right to a jury trial, that error is presumed prejudicial, whether there's a trial objection or whether there is not a trial objection. So the real question before this court, in my view, is not whether it is firmly convinced that the jury would have returned the verdict that it did, but for instructional error. The question is whether this court can be confident beyond a reasonable doubt that instructional error had no effect on the jury's verdict. And given the evidence in this case,
I just want to be clear. So you're saying that once a defendant requests an instruction, even if the defendant is shown a set of the instructions that are about to be given and is asked whether there's any problems with that set and says nothing, there's a Section 5 problem?
in addition to our contention that this is preserved as instructional error.
Right.
Yes, Your Honor.
Okay.
And I think that's pretty clear. If this court looks at its case law, it clearly illustrates that defendants at common law, when Kansas's Constitution came into existence, had a right to a jury trial on lesser included offenses if a judge decided that it was legally and factually appropriate to instruct on a lesser. And that's what we have in this case. The judge clearly ruled that it was legally and factually appropriate to instruct on the lesser, but the jury was not given an opportunity to convict on that lesser due to the non-provision of the elements instruction. So that puts us in the area of constitutional harmless error review. I don't believe that the state's error, that the state can meet that burden, because the evidence of premeditation in this case was quite weak. We have homicidal acts that occurred within a brief span of 15 seconds. We have no apparent motive for a premeditated killing. We have no direct evidence of premeditation. We have basically a vacuum of evidence that permitted jurors nothing more than a guess as to what was going on in the mind of a perpetrator prior to intentional acts that resulted in death. It is not at all clear that a properly instructed jury would have convicted on first-degree premeditated murder. And based on that, we would respectfully ask this court to remand this case for a new trial. I would also note, even that if this court were to agree with the state's contention that we are in the territory of clear error, it's still my view that Mr. Miles is entitled to a new trial for two reasons. First, I think we have met the traditional clear error burden. Given the weakness of the state's evidence of premeditation, I believe this court should be firmly convinced of a real possibility that a properly instructed jury would have returned a different verdict. Additionally, as a noveler argument, I would contend, for reasons outlined in our briefs, that an appellant's showing of clear error should not turn on prejudice. And my reason for making that argument is KSA 22-34-14-3's plain language. The plain language of that statute permits reviewing courts to assign error to jury instructions that are, quote, clearly erroneous. The plain language of the statute does not permit assignment of error to clearly prejudicial instructional errors. The error in this case was obvious. The state concedes it in its brief. I don't think that anybody could plausibly contend that the district court was right not to instruct on a verdict option offense. Because the error is obvious, it should be reviewable pursuant to the plain language of statute. And I concede that our advocated interpretation of KSA 22-34-14-3 is at odds with this court's longstanding precedent. But recently in State versus Waldschmidt, this court noted that unreasoned judicial repetition should not inform this court's interpretation of KSA 22-34-14. This court noted in its State versus Williams case that its clear error reversibility standard really isn't tied to the plain language of statute and is at odds with the conception of clear error that Kansas courts employed prior to the enactment of KSA 22-34-14. At common law, the common law that KSA 22-34-14 was intended to codify, clear error meant error that was obvious, not error that was obviously prejudicial. This is all outlined in this court's Williams opinion. And for that reason, I would contend that even if we do get to clear error, which I don't think we get to in this case, we still have reversible error. Unless this court has any questions on the instructional issue,
I ask you to briefly summarize your constitutional claim with respect to the law as it existed in 1859.
Yes, Your Honor.
On lessers, essentially.
On lessers. So I think if this court looks at its own case law, it supports two notions. Number one, the judge of a trial got to decide on whether to give lesser included offense instructions. But number two, as a corollary to that, if a judge decided that it was legally and factually appropriate to instruct on lessers, that had to go to a jury, and a defendant had a common law right to jury fact finding on that matter.
And can you give me what cases are you relying on for that?
Berberich.
Or you can even just point me in your brief to.
Now, as far as cases that have dealt with this precise issue, I don't believe that there are any because this is a novel issue. Okay. But the understanding of common law is set out in the Berberich opinion. That's from 1991. State v. Love, I think, illustrates the idea that judges decided on whether to give lesser included instructions, but that the right to jury trial existed if the judge made that.
Would it be correct to summarize your argument to be that you don't have case law from the 1860s that you're relying on here? You're relying on modern day cases that.
Well, I'm relying on modern day cases that recite what common law was at the time. I would also rely on the Beck opinion. That's a United States Supreme Court opinion that is summarizing common law, obviously at an earlier point in American history.
So I appreciate that. And my follow-up would be, this is an odd case because it's not a case where no lesser instruction was given. I mean, the jury was presented with the lesser included of second degree intentional, but the elements were not provided. So how should I just wanted you to articulate how you think we should think about that. It's not as though the jury couldn't have returned a verdict of second degree intentional, right? The instruction said they could.
Well, It was on the verdict form, so I suppose the jury had the raw power to do that. My view, though, is that there was no principled way of exercising that raw power without understanding.
And that goes to, there's another test that we sometimes apply to instructional error claims, which is, was it confusing to the jury? And I'm just wondering why that might not be the appropriate test here, given that not only was it on the form, but in the actual instruction, you have the elements instruction on premeditation, and the instruction immediately following says, this crime includes the lesser of second-degree intentional, and you can convict of either premeditation, second-degree intentional, or acquit. Isn't that what the instruction says?
Well, Your Honor, I think it goes beyond just confusing, although even if this court decided that the only problem with the set of instructions in this case was that it was confusing, I still think we get to reversible error. But I think it goes beyond that because, you know, without an elements instruction, there's just no principled way that a jury can make this decision. There's no way that a jury can say this was an intentional murder without knowing what second-degree intentional murder is. It's functionally the same thing as not instructing at all, is my view. And that's probably my best answer to your question.
There was many times in lesser included cases, there's kind of a sequential consideration, for lack of a better way to put it, in the instruction package itself. I'll paraphrase. This is something, if you cannot agree the defendant is guilty as charged in first degree murder, then you shall consider the lesser included. That sequential type of consideration isn't in this package as I am reading it. Is that correct?
My recollection, Your Honor, is that there is instruction that the jury can convict on intentional if they did not reach a unanimous verdict on first degree premeditated. And I believe I'm going off the top of my head. I may be
just looking at instruction number 9, and I was, maybe there's others.
Off the top of my head, I believe it might be instruction 11, Your Honor. I don't have the record in front of me.
Yeah. Anyway.
Well, that would certainly compound.
Yeah. Typically, there's a kind of a sequential consideration, because my question basically goes to, they did convict as charged of premeditated, first degree premeditated. But it appears that the way the jury was instructed to consider that is they're to consider that together with second degree as opposed to independently of one another. Is that right? Well, it includes the charge of intentional second degree murder. And you make, anyway, I noticed the absence of it.
That's certainly significant, Your Honor, and that just reinforces our position that this is prejudicial reversible error.
Okay.
I see I've gone over my time limit. As far as the prosecutorial error claim, I would just note that to me, that seems like pretty clear-cut error pursuant to this court's case law. And that would also independently require a new trial. We would respectfully ask this court to reverse and remand for a new trial on the basis of instructional error, on the basis of prosecutorial error, or on the cumulative effect of those two errors together.
Any other questions? Thank you, Mr. Shire. Mr. Maloney.
Thank you, Your Honor. May it please the court and counsel, Assistant District Attorney Matt Maloney for the state. I'm going to start at the end there because it's fresh in my mind, where counsel argues that it was pretty clear that there was prosecutorial error in discussing premeditation. And I strongly disagree with that. I think when you read the prosecutor's closing, both prosecutors' closings in their entirety, in context, as we always have to do, you see a very accurate description of premeditation. This was not something where either prosecutor ever said that premeditation can be formed in an instant, which is essentially the argument that the defense has made. The prosecutors here walked through evidence starting from well before the killing. pointed out the fact that he made this statement to the young man in this car about, have you ever shot a gun, while they were still on the way to the victim's apartment. And then mentions the fact that when they get to the apartment, the young man saw the defendant with his arm raised, extending the gun, pointing at the victim, and argued that that was further evidence of premeditation before even firing the first shot. And then the prosecutors pointed to the evidence about the number of shots that were fired. There is nowhere in there. Now, the comment that she made in the initial portion of closing argument, that the defendant really is focused on, is each trigger pull is another act of premeditation on the part of Jeremy Miles. Now, again, if you divorce that from all of its surrounding context, that might seem problematic. But right before that, literally the sentence before that, she says, it's not just one shot, it's not just two shots, it is 12 distinct shots. And this court's case law talks about the fact that the number of shots, the amount of time that the act takes, are certainly factors that can factor into premeditation. And I set forth the evidence in the brief. It's not just the number of shots, but it's the sequence. There's a shot, and then you can hear this on the audio recording. There's then a pause. Then there's a sequence of 4 more shots, another pause, and then a sequence of the final 7 shots. All told, it took about 15 seconds. The physical evidence shows that there were shots fired at the couch, which is where the victim was initially seated. The evidence shows that the victim obviously did not die instantly because he was able to crawl from the couch several feet across the floor. And then you see the bullets essentially followed him. And so all of that, the sequence, the number of shots, the pauses in the shooting, 2 pauses in the shooting, those are all absolutely factors that the prosecutor rightfully pointed to. And not only did she not say that premeditation can be formed in an instant, at the start of her argument, she expressly said the opposite. She first of all, she pointed to the instruction and directed the jury's attention to that. But then she also said that it requires more than something to be formed in the instant. And so our position is very much that there was not only not obvious and clear prosecutorial misstatement or error, but there was no misstatement at all. When you look at those comments, everything that they said, both in the initial and rebuttal closing, was appropriate. Now addressing issue 1, and without question, the district court made a mistake in this case. It's clear from that initial instruction conference that not only the district court, but that both parties agreed that a lesser on intentional second degree was warranted. The court planned to give that. I think when you look at the record, it actually is pretty clear why this error happened or how it came about. There were a lot of revisions to the instructions in this case. And on that Friday, it's pretty clear that the judge's assistant, I think everybody had initially, she thought that they had reached the final decisions on the instructions, and she was surprised that they were going to have to go back and tailor them even more. And she made the comment that she would come in over the weekend if necessary. And then the judge stepped up and said, no, don't worry about that. I'll do it myself. And so this is the rare case where the judge himself is the one who actually drafted the final written instructions. We come in on Monday. The court says up front, I have handed both parties a copy of the new instructions. And we know he did because the state pointed out a separate mistake in a different instruction. So we know for a fact, I think one of the arguments that the defense made in their brief is that the defense attorney really didn't have a chance to address the mistake that occurred between the time that he filed the proposed instructions and what occurred. But we know that's not true because this, again, the state did point out a mistake. So the defense doesn't catch it, and to be fair, neither did the prosecution, and obviously the court didn't either. But I think that's kind of the genesis of why this occurred. But in any event, then the end result is that the defense was given an opportunity, did not object to that instruction that was issued. So there was an instruction. I know that counsel has argued that functionally this is the equivalent to not instructing at all, not giving the lesser. But I would disagree because clearly that instruction does tell the jurors that they have the option of convicting him of the charged offense or the lesser offense. Undoubtedly, the instruction then fails to contain the elements. Our position with respect to harmlessness is that, and I pointed this out in the brief, ironically, the fact that the instruction completely omits the element, I would argue, makes this more likely to be harmless than if the instruction had simply omitted one element or two elements out of a several element instruction. Because if there's an instruction, if there's an element instruction or a crime that, let's say, includes 4 elements, and the court gives an instruction and it includes 2 or 3 of the elements, then the jurors are simply going to have no way or no reason to know that the instruction is somehow inadequate. Unless there's a jury full of legal scholars who know all of the elements of every crime in Kansas, they're not going to know whether an instruction that contains 3 elements should actually have contained 4 or 5. But here, you don't have to be a legal scholar to look at it and see, the court just told us that we can convict him of this lesser offense that's called intentional second-degree murder. But unlike all of the other crimes that are charged in this case, the court doesn't give us any guidance whatsoever on what that means. So I think clearly the jury, anybody with common sense would have been aware that there was something lacking. And that's where I think the fact that the jury never asked a question about that would pretty strongly indicate that they never really got to the second degree because they were unanimous on the premeditated.
There was no, many times in lesser included offense instructions includes an instruction on how to consider the lessers. And that I don't see that in the package. That's what I was trying to point out to Mr. Shire, is that typically you consider the first, and if you can't agree, then you go to the next less. I'm paraphrasing.
Right.
And am I right? Typically, Mr. Mahoney, that's typically a part of the package. It's not here.
Yes, I believe you are right, Your Honor. The only thing that I cited in my brief.
With that, I think you could then make the argument, well, they did what they were instructed to do, first considered, were unanimous. There's no need to go on to the lesser. But that isn't what the instruction says. I mean, the instruction says you shall consider both, essentially, is what it says. And how do you consider both? You're not fully understanding of what you're supposed to compare them to or consider. That's where I'm stuck.
Right, and I definitely agree that my argument would be even stronger if it did have the sequential language in there. But I still think that the fact that the instruction is just so wholly inadequate as far as omitting any elements of it, I think it's hard for me to think that there's any reality in which a jury would see that error, realize that, hey, there's nothing here to guide us. And if they had any question in their mind about the premeditation or whether this was just second degree intentional, that they then wouldn't call it to the court's attention and say, and ask a question and say, Judge, we noticed that there's no elements in here. What is that? Or Judge, we are uncertain right now and we would like some guidance on this issue. And so I think, and also the fact that the prosecutor did discuss this in her closing argument and basically said, look, you've got the instruction on premeditation. We also have this lesser of second degree intentional. 2 of the 3 elements are the same. So essentially letting the jurors know that as the title of the charged offense would indicate, that the only difference between the 2 is the absence of premeditation from the intentional second. And of course, the defense didn't challenge the prosecutor's statement because it was accurate. Perhaps if it had been something, I know obviously that the statements or arguments of an attorney are not the same as if there had been an actual instruction. And I'm not saying that they should be entitled to the same weight. But where the prosecutor makes an uncontroverted statement about something as simple as, hey, the difference between the charged offense and the lesser is that you've got this one missing element, this one element that is absent from the lesser. The defense doesn't contest that because there's no reason to. The jury then never asks a question about what the elements are. I think that when you start adding all of these things together, you have a very strong argument that there simply was not a doubt in the juror's mind as to premeditation. And then you add in the way that this case was presented. This was not a case, frankly, where, now clearly, the parties and the court had all agreed that the court was going to instruct on the lesser of intentional. And I think, going back to the first argument today, based on this court's case law, I think that would have been obviously what guided their decision to go ahead and give that. But this was not a case where premeditation was the focus of the defense at all. The defense's position was clear. Jeremy Miles had no role in this killing, and in fact, did not even go to the victim's apartment that day. Now, of course, the jury's always free to decide as they see fit. But when you have a case where the defense is saying flat out, I had nothing to do with this killing. I wasn't even near the crime scene. That further adds to our harmless error argument. And then the overwhelming evidence of premeditation. This is a case, one of the rare cases. Now, it doesn't rise to the level of the previous case where he literally said, I'm going to shoot this guy in the head. But it's somewhat close in the fact that as he's driving over to the apartment, he says to his wife's brother, have you ever shot a gun before? He then goes into the apartment. He fires 12 shots at an unarmed man over 15 seconds as the victim tries to crawl away. And then when he gets back to the vehicle after the killing, he makes another statement about how he's on a killing spree. So this is incredibly strong evidence of premeditation, very rare, I would say. Usually we do have to prove premeditation more circumstantially, but here we have very strong direct evidence of premeditation. And then you have a defense that doesn't even remotely try to focus on premeditation. This isn't something where they made an alternative argument and said, our position is that my client was not there, but even if you disagree and you think otherwise, there's no indication that he thought this over beforehand, that it was just a spontaneous act, that something happened in that apartment or that he was provoked. There simply is none of that. So I think, again, no question that there was a mistake made here, and I'm sure that the district court would be the first to acknowledge that. And obviously the state is acknowledging that throughout this appeal. But when you look at all of these factors, I just have a hard time seeing a case where there would be a stronger argument that this error was in fact harmless. And so our position is that this mistake, while unfortunate, did not affect the outcome of trial under any standard that this court chooses to utilize in weighing that. And again, just to summarize my position on the second issue, I think that the prosecutors did an excellent job in this case of accurately pointing to the factors that this court has authorized in the concept of premeditation. And so our position is that there was no error beyond the instructional error in this case. And we would respectfully ask that the defendant's convictions be affirmed.
Can you briefly recite your position with respect to the constitutional claim, the Section 5 claim?
I don't know that I necessarily have a great amount to add to that, other than the fact that Gleason does talk about the fact that, even under that standard, the presumption of prejudice can be overcome. And in that case, they essentially looked to the strength of the evidence.
Well, do you agree that we ought to apply? I mean, is Section 5 implicated here?
I think under, and I was just refreshing my recollection on Gleason as counsel was arguing. I think that if you continue to apply Gleason, I do acknowledge that there would be support for his argument there, that that would seem to be, because, you know, in Gleason, there was the missing element. This case is a little different because, as I pointed out, just the way that the error came about and the fact that it's wholly missing any of the elements instead of just omitting a particular element. But I do think that I would certainly be open, and I would assert that it would be appropriate for you to reconsider whether Gleason was correctly decided, because I do think that in a situation like this, that clear error should still be appropriate given the way that this came about. But ultimately, my position is that even under Gleason, just like in Gleason itself, that the error was harmless.
Any other questions, colleagues? Thank you.
Thank you, Your Honors.
Mr. Shire, you reserve 3 minutes.
Thank you, Your Honor. I'd like to make a brief point on harmless error and then cut to the prosecutorial error claim. As I understand the state's harmless error argument, it's essentially that trial evidence was overwhelming because of the testimony and statements of Kareem Hendricks. Well, a jury may not have decided that Kareem Hendricks's testimony was reliable. A jury may not have decided that his statements to police were reliable. It was the defense at trial that those statements and that testimony was not reliable. So I don't think when conducting harmless error review that this court can assume that the testimony of this particular witness is something that a jury would have given credit to. With regard to prosecutorial error.
What about the, I'm sorry to interrupt you, but the other argument about the, once inside the apartment, the physical evidence and what you can hear on the ring, a series of shots, pause, another series of shots, pause, and the final sort of series of shots, evidence that the defendant was moving in the process. Just, I want to incorporate that into your harmlessness argument.
Absolutely. So that evidence, we're talking about a pause of seconds. These are 12 shots fired in the course of 15 seconds. That's approximately 1 shot a second. I think that that is not overwhelming evidence of premeditation. I think somebody can be acting on impulse for a period of 15 seconds. And I think a jury may easily have found that. That does cut neatly to the prosecutorial error claim. The prosecutor here argued, quote, each trigger pull is, quote, another act of premeditation. The prosecutor did not argue that you could infer premeditation from the number of shots. The prosecutor argued that each trigger pull was in itself an act of premeditation. That conflicts with Morton, where this court found reversible error when a prosecutor argued a squeeze of a trigger is all it takes for premeditation. It contrasts with Hall, where this court found that a prosecutor erred by saying that premeditation could be formed within 4 rapidly fired gunshots. It contrasts with I believe, I don't have the other case in front of me, but it simply is not in line with this court's case law. And the other problem with the argument is that there is no evidence whatsoever as to which of these 12 gunshots may have independently caused death. After there is an act that independently causes death, we have a line of demarcation. No premeditation can occur after that point. If the first gunshot in this case would have independently caused death, then there could be, as a matter of law, no premeditation after that point. So that provides another reason why the prosecutor's argument is a misstatement of law.
Any other questions? Mr. Shire, thank you very much for your arguments. The court will take this matter under advisement, and we will now be in recess for 15 minutes and resume at 10:35. Thank you very much.